But let's return now to New South Wales Attorney General Mark Speakman. Mark, great to speak with you again. Back to the issue of this bill to criminalise coercive control. How do you actually prove that a perpetrator had intention to control?
Well, you don't have to get that out of the mouth of the perpetrator. You can prove that from the surrounding circumstances, so that if someone, for example, tells their partner, you're not to see your family, you're not to see your friends, and cuts up their credit cards, you don't have to have it out of the perpetrator's mouth. You can infer intent from the surrounding circumstances. And that's the very essence of what coercive control is. It's an intention to control or dominate someone else.
How early can you actually prove this intention? Because is it often a pattern that's formed over time?
Well, the legislation has to be very flexible because no case of coercive control will be exactly like any other. And that's why, unlike some other jurisdictions, we haven't prescribed a minimum number of episodes before it becomes a course of repeated or continuous conduct. So it's a fact-by-fact case, but we certainly don't want any sort of arbitrary maximum number or arbitrary minimum number of instances. And that's why police training is so important, to pick up coercive control, which will be very fact-specific, different from case to case, and typically covert, not all that obvious to the outside world.
How will they be trained?
Well, we've allocated an initial $5.6 million that was announced yesterday. That will be for training police, for educating judiciary, and also building up community awareness. I think a lot of people, when they think of domestic violence, they think of a woman cowering in the corner who's been beaten, battered, bruised. But domestic abuse advocates and the victim survivors will tell us that commonly what is worse than those bruises and battering is the insidious control. So this will be a very different way of policing, and that's why it's important to have a long lead time between the legislation passing Parliament and commencing. So we're looking at that it wouldn't commence before February 2024 and as late as July 2024.
Domestic Violence New South Wales says that this may give false hope to survivors, as it may be very difficult to prosecute, could end up traumatising the people it's aimed to protect if the bill isn't passed without further consultation. What's your response to that?
Well, there's a few responses. Firstly, we've had 2.5 years of discussion and consultation. We've had at least 7 rounds of consultation. That included a discussion paper, a parliamentary inquiry that went for 9 months, with 150 written submissions and 70 oral submissions. We had an exposure draft in July and August. We've conducted about 30 targeted roundtables. There has been an enormous, unprecedented amount of consultation. I don't accept that there is one voice in the domestic and family violence sector. We have a number of members of that sector indicate to us they support what we're doing. No to Violence, which is Australia's leading coordinator of men's behaviour change programs, supports what we're doing. Annabelle Daniel, who is the CEO of Women's Community Shelters, agrees we should be criminalising now, then have a period to implement, and then review the legislation, which was what we're proposing to do in a few years' time. In terms of traumatising victim survivors, there are a couple of key points to make about this legislation. You don't have to prove that a victim survivor was harmed or had actual fear. Rather, it's a question of whether the reasonable bystander would look at the course of conduct and say that's likely to instill fear of violence or interfere with someone's day-to-day activities. And second, the intention that has to be proved is the intention to coerce or control, not the intention to harm. So if you've got a perpetrator who says, well, I'm doing this for the victim survivor's own good, she's hopeless with money, she shouldn't be seeing her friends or family, they're horrible people, and the perpetrator has somehow convinced themselves that they're doing it in the victim's best interest, that won't be a defence. It's a question of whether there's an intention to coerce or control. And this is an approach that's been endorsed by Professor Evan Stark, who's the world's leading expert on coercive control.
Okay. The proposed legislation only covers intimate relationships. Why doesn't it cover family relationships?
Well, we made it very clear when we responded to the inquiry last year that in this session of Parliament we will be legislating for intimate partners only. So we are leaving open the possibility further down the track of expanding that to other relationships when there's a review in a few years' time. We want to see how it goes first with intimate partners. But a couple of things. First, uh, the dynamics of coercive control are clearest in an intimate partner or former intimate partner relationship. That's where the core of the problem is. And second, there's an enormous evidence base linking domestic violence, intimate partner homicides with coercive control. When the coroner and her team looked at 112 domestic violence intimate partner deaths in New South Wales, 111 of those were preceded by coercive control. So it's clearly a red flag for homicide. We don't have the same evidence base in other relationships. At the moment, other relationships are still protected by other parts of the criminal law: stalking, intimidation, general assault offences. But that's something we want to evolve over time and see how this works, which is a huge leap in New South Wales criminal law. Bed it down and over a course of a few years come back and see whether we need to lower the bar for the mental element, whether there's an adverse impact on Indigenous people, whether the penalty is high enough, whether we expand it to other relationships. And of course, this is also a balancing exercise. It's while we want to do our very best for victim survivors, we've also got to be aware that Aboriginal people are probably the most incarcerated people in the world. And over half of those at the moment who are incarcerated for domestic violence, stalking and intimidation offences are Aboriginal. So we've got to be very careful that we get the balance right, that we are not exacerbating an already tragic problem in our Indigenous communities.
Mark Speakman, we do have to leave it there. Thanks so much for your time. Appreciate it.
Thanks for having me on.